Building upon the previous section that explored when a public report is required and its consumer protection purpose, it is equally important for Arizona licensees and developers to understand how the public report directly governs advertising practices related to subdivisions. Advertising is one of the most regulated areas of Arizona real estate, particularly when it comes to promoting subdivided or unsubdivided lands. The state's goal is to ensure that any advertisement made to the public reflects the facts disclosed in the public report, avoids misleading or exaggerated claims, and complies fully with statutory and administrative regulations established under ARS Sections 32-2153, A16, ARS Sections 32-2181 to 32-2185, and AACR 4-28-502. In Arizona, no advertising, marketing, or solicitation of lots, parcels, or units within a subdivision may begin until the Arizona Department of Real Estate, ADRA, has issued a public report for that subdivision. This requirement, rooted in Arizona Revised Statutes, Section 322181A, ensures that buyers are not enticed to enter into transactions based on incomplete or unverified information. The issuance of the public report represents ADRE's verification that all material information about the subdivision, such as title status, legal access, water and sewer availability, and development conditions, has been disclosed. Only after this approval may developers and licensees begin public promotion, and all advertising must reference the public report number. Advertising a subdivision before the public report is issued is considered a violation of state law and constitutes unprofessional conduct under ARS Section 32-2153A16. This can result in administrative sanctions, fines, license suspension, or even criminal prosecution under ARS Section 32-2195.21. The rationale for this strict prohibition lies in Arizona's commitment to prevent fraudulent or premature marketing, a problem that historically led to consumer losses when subdivisions were sold before infrastructure, water access, or zoning approvals were in place. To illustrate, consider a developer planning to sell 20 residential lots in Pinal County. The lots have been surveyed, but the public report has not yet been issued. A sales agent, eager to begin marketing, posts online advertisements claiming, "Now selling lots with mountain views, utilities ready," without disclosing that no public report exists. When Audrey reviews the advertisement, the developer is fined for premature marketing, and the broker is disciplined for failure to supervise under ARS Section 32-2153A10. Such cases emphasize that the issuance of a public report is not just a procedural milestone, but a legal prerequisite for public advertising. Once the public report has been issued, advertising content must accurately reflect the facts contained within it. According to AACR 4-28-502F, all advertising must be truthful, clear, and not misleading. This includes avoiding superlatives or vague claims, such as guaranteed profits, risk-free investment, or exclusive luxury development, unless these statements can be factually substantiated. Any material change in the subdivision, such as changes in access, utilities, or financing terms, requires an amended public report before continuing to advertise those features. Additionally, all advertising must display the ADRE-issued public report number and identify the broker or developer responsible for the advertisement. Anonymous or unbranded advertisements are prohibited. R4-28-502A mandates that all real estate advertising must clearly identify the employing broker, ensuring that the public knows who is responsible for the information being presented. This rule extends to print media, online listings, social media, and even signage posted on the property. For example, A developer in Maricopa County receives a public report for a new master plan community named Desert Canyons. The marketing department prepares promotional materials showing amenities, such as a future golf course and recreation center, that have not yet received county approval. The developer's broker reviews the materials and immediately flags the issue, citing R4-28-502D, which prohibits advertising features or amenities that are not yet completed or approved. The broker instructs the developer to revise the advertisements to include an accurate disclosure. Amenities shown are planned and subject to county approval. By doing so, the broker ensures compliance and protects both the firm and consumers from potential misrepresentation. Another key requirement concerns foreign or out-of-state advertising. Under ARS, Section 32-2183B, any advertisement targeting Arizona residents for land located outside Arizona must still meet Arizona's advertising standards and include full disclosure of where the land is located and whether an ADRE public report exists. This ensures that Arizona consumers are afforded the same protections regardless of where the property lies. Licensees must also exercise caution when participating in cooperative advertising with unlicensed developers or third-party marketers. According to AACR 4-28-502H, a licensee may not advertise or promote any subdivision unless they have verified the existence of a valid public report and have received permission from the developer or subdivider. Participating in unapproved marketing exposes the licensee to liability, even if the developer is the one primarily responsible for the violation. Example scenario: a real estate salesperson advertises lots in a new development in Mojave County on social media, reposting materials from the developer's marketing campaign. The developer claims the lots are ready for immediate construction, but ADRE later finds the development lacks legal access and no public report has been issued. Even though the agent did not create the content, they are held accountable for disseminating misleading information under ARS Section 32-2-153A-16 and R4-2-8-1101B for failure to verify accuracy before sharing. Review summary: advertising. A subdivision before the issuance of a public report is prohibited by Arizona law. Once issued, all advertisements must accurately reflect the contents of the public report, display the ADRE assigned report number, and identify the responsible broker or developer. Licensees must verify all advertised information, avoid unsubstantiated claims, and refrain from promoting unapproved amenities or improvements. Compliance with ARS Sections 32-1812232-2185, ARS Section 32-2153, and AAC R4-28-502 ensures that advertising remains honest, transparent, and aligned with Arizona's consumer protection goals. Discussion prompts. Why does Arizona prohibit advertising a subdivision before a public report is issued? Answer: to prevent misleading the public and ensure buyers receive verified, accurate information about the subdivision's condition and legal status. What must be included in subdivision advertising once a public report is issued? Answer: the ADRE public report number, the broker's name, and accurate representations consistent with the approved report. What is the best practice for a licensee before posting or sharing subdivision marketing materials? Answer: verify that a valid public report has been issued and review all materials for factual accuracy and compliance with ADRE rules. Closing remarks: advertising in real estate is not just a marketing function, it is a legal responsibility. The public report requirement ensures that all promotions of new subdivisions are grounded in truth, transparency, and verified disclosures. For Arizona licensees, compliance is not optional. It is fundamental to maintaining public trust and professional integrity. Every sign, social media post, and brochure carries the weight of Arizona's consumer protection laws, reinforcing the principle that informed buyers are protected buyers.